Okay, let's unpack this. We are diving deep into one of the most emotionally charged and legally complex areas of American justice, the family court system.
It's a place where, personal tragedy meets this very rigid institutional procedure.
Right. And where disputes over something as personal as child custody can just explode into these decades-long civil rights lawsuits.
That is precisely the terrain we're exploring today. We're focusing on two really extraordinary sagas. Both involve mothers and daughters fighting for justice against what they see as systemic failures.
Or in some cases, what they allege is outright corruption by court actors.
Exactly. And the stakes, they couldn't be higher. We're talking about constitutional rights, custody of children, and whether you can actually hold government officials accountable.
And our mission today is very specific, tailored directly for you, our listener. You want to understand in really granular detail what happened in the decades-long case of Presley Hardwick and her mother, Deanna Fogerty Hardwick, in California.
Yeah, the focus is on their legal strategies. What did they do in court? What did they actually win? What did they lose? And what were these just formidable legal obstacles they were up against?
And then we have to compare that whole long, difficult kind of analog path with the very modern, very high-profile fight of Meg's story, which is based mostly in Missouri and Kansas.
Meg's pursuit of justice is a whole different ballgame. It involves this rapid-fire federal litigation and, maybe most critically, this huge national digital advocacy campaign.
That contrast really is the foundation for this whole deep dive, isn't it? We're comparing these two paths. One is seeking accountability through, damage claims against court actors who are wrapped in this cloak of immunity.
And the other is demanding immediate federal intervention, transparency, and broad systemic reform. It's a battle of precedent versus visibility.
A 20-year legal war versus a 2024 digital campaign.
And we have extensive source material to guide us. We've got judicial findings, raw trial transcripts, appellate briefs that detail the immunity defenses in the Hardwick case.
And on the other side, the detailed public and legal timelines that have been established by Meg's own advocacy.
Right.
So let's start with Meg's story, because it really does feel like the modern blueprint for how parents are tackling what they see as these severe institutional failures.
Okay, so Meg's battle, it didn't really start in the family court system. It started with her surviving a deeply toxic and controlling marriage in Missouri.
And the sources lay this out pretty clearly.
Oh, yeah. They detail a period starting around 2013 that's just marked by serious emotional and sexual abuse, domestic violence, financial deceit, and just this profound psychological control over her life. And she was a mother of 5 through all of this.
That level of sustained control, it can be absolutely paralyzing. What was the catalyst? What was the one moment that pushed her to take that first legal step?
It was a discovery that kind of transitioned her nightmare from this private hell into the public record.
Okay.
She found a hidden GPS tracker on her vehicle in 2013. And that finding, it gave her concrete, irrefutable evidence of the extreme surveillance and control she was under. She immediately went and got an ex parte order of protection.
And that swiftness is so critical. And criminal charges followed the discovery of that device, right? Which must have added serious weight to her claims.
It did. But her first major legal victory, the one that should have set the stage for everything else, was the divorce itself.
And it was a big win for her, wasn't it?
It was a massive win, seemingly on every single front. The litigation in Cass County, Missouri, resulted in a 30-page divorce decree.
30 pages.
30 pages. It was, almost encyclopedic in validating her claims. The court explicitly documented the pattern of verbal abuse, physical abuse, financial deceit, the surveillance. It was all there.
A 30-page document suggests the judge was being incredibly meticulous, laying out these findings of fact that should have been ironclad protection for her future.
You'd think so. And the court went even further. They took the really unusual step of finding her ex-husband's chosen expert witness to be biased, and they rejected him entirely.
Which is a powerful statement from a judge about credibility.
A huge statement. And on top of that, they barred the family nanny, who, by the way, later married the ex-husband.
Oh, wow.
They barred her from being involved in caregiving due to documented harassment and boundary issues.
So she had this comprehensive victory on paper. It validated her entire experience, put up specific guardrails around her ex-spouse and his associates. But the source material makes it devastatingly clear that this powerful piece of paper, it was almost meaningless.
The enforcement was described as almost non-existent.
How will that happen?
The conflict didn't stop. It it migrated. It transformed from domestic violence into what she calls legal abuse.
Okay, break that down. What does that mean in this context?
When the case moved to Johnson County District Court in Kansas, the patterns of manipulation and harassment that the Missouri court had already recognized, they didn't stop. They were just, channeled through the court system itself.
Directed through court actors, you mean?
Exactly. Judges, guardians, ad litem or GALs, and court-affiliated therapists.
And this is that slow-motion legal war we hear about. The constant grinding pressure of motions, endless discovery requests, temporary orders that challenge every single aspect of her parenting.
Turning the court process itself into a financial weapon. It's designed to drain your resources, your time, your will to fight.
And it's important to remember all of this was happening while she was still trying to live her life.
Right. She was maintaining what, from the outside, looked like a normal suburban life. She's raising 5 kids, managing school. Advocacy.
Like leading efforts against school mask mandates.
Yeah, so she was fighting this two-front war, defending her family in the courts, and at the same time engaging in civic life. That level of, internal resolve and her meticulous documentation, that became critical later on.
But all of that compartmentalization, it just came to a brutal, immediate halt earlier this year. And this is where it gets really interesting, because this is where the custody dispute allegedly transitions directly into a federal civil rights violation.
We're talking about the 2024 catastrophe, specifically January 29th, 2024.
So what happened on that day?
In a single shocking action, a court-appointed guardian ad litem, a man named Randy McCalla, obtained an ex parte emergency order.
An emergency order for what?
It stripped Meg of custody of all 5 of her children and completely cut off her contact with them.
All 5, instantly.
Instantly, and it was all based heavily on the report of a court-affiliated therapist.
Okay, let's slow down on that term for our listeners. Yeah. Ex parte. But that means the order was obtained by one side without the other side. In this case, Meg even being there, right?
Exactly. She wasn't present. She wasn't informed. She had 0 opportunity to participate in that hearing.
The order was signed. The children were removed. I mean, that's a constitutional crisis for a parent.
It is. Her core claim is that her fundamental rights to due process under the 14th Amendment and her right to familial association, the basic right to raise your children, were completely disregarded.
No proper evidentiary hearing, no chance to testify or present her side.
No opportunity to cross-examine the therapist or the GAL about their findings before the removal happened. Nothing.
The very concept of due process is the right to be heard. To lose custody of 5 children in an instant without being heard it's fundamentally shattering. But the crisis deepens, right, when we look at the evidence that was actually available at that time.
This is the pivotal detail. This is what defines her entire legal strategy going forward. The Kansas DCF, the Department for Children and Families, had already investigated the allegations that led to the removal.
And what did they find?
They found them unsubstantiated. They expressed no safety concerns about Meg's mothering or the children remaining in her care.
Wait, so the state agency responsible for child safety cleared her. But these court-appointed private actors, the GAL and the therapist, they successfully pushed through an order based on those same refuted allegations.
Precisely. The sources confirmed that a DCF investigator, Michelle Merritt, actually informed the GAL before that January 29th order was executed that the accusations were untrue and did not justify the removal.
So this exculpatory evidence, the state's own finding of unsubstantiated, was allegedly ignored or concealed by the court actors who were pushing for this removal.
That's the allegation, and that suggests that the legal system wasn't just slow or biased. It was allegedly acting contrary to the best available evidence at the time.
So how do you fight back against that level of institutional pressure and alleged coordinated action?
Meg didn't wait. She didn't wait for the family court to correct itself, which, can take months or years. She immediately filed multiple federal civil rights lawsuits.
In the United States District Court.
Yeah.
And what's really extraordinary here is that she did this pro se.
Yes, representing herself. She had to learn the incredibly complex machinery of federal civil rights litigation in real time while fighting to see her own children.
And for anyone listening who hasn't tried to navigate federal court, filing pro se is like trying to build a car engine with a manual written in a language you don't speak. The legal standards, the procedural requirements, they are immense.
And she had to master all of that. Her suits are primarily brought under three really critical federal civil rights statutes: 42 U.S.C. Section 1983, Section 1985, and Section 1986.
Okay, so Section 1983 is the main one, right? Let citizens sue state actors, people acting under color of state law, for violating their constitutional rights.
Right. And in this context, that would include the GAL and the court-affiliated therapist.
But the addition of sections in 1985 and 1986 is really significant here. What do those statutes add to the case?
Those statutes address conspiracies. Section 1985 deals with conspiracy to interfere with civil rights, and 1986 deals with neglecting or failing to prevent such a conspiracy.
So by using all three, she's not just claiming her rights were violated by one person.
Exactly. She's alleging that the GAL, the therapist, and potentially others coordinated or conspired to violate her rights, specifically her right to familial association and due process through this sudden ex parte removal.
And she has some powerful, pivotal evidence to back up those conspiracy claims.
She does. The source material details a conversation she recorded in June of 2024 with that DCF investigator, Michelle Merritt.
The same investigator who cleared her before the removal.
The very same. And Merritt confirmed on that recording that the initial allegations were not substantiated, that she had no concerns about Meg's parenting, and this is crucial, that she believed the children's statements were likely coached.
Wow. That directly contradicts the entire narrative that was used to justify the January 29th removal.
It provides concrete evidence for her federal complaints, alleging systemic misconduct and, yes, conspiracy.
So she's pursuing justice on these two parallel tracks. There's the incredibly difficult path of federal litigation for damages against individuals.
And then there's the path of public transparency and advocacy.
That's the key distinction, I think. She recognized early on that the legal path is slow, it's expensive, and it's protected by these immunity shields we're going to talk about.
So she converted her crisis into a national platform. She launched Stand With Meg and justiceformeg.com. This isn't just about her personal story anymore. It's an ecosystem designed to generate political and public pressure.
And the sources cite massive visibility, over 15 million Instagram views since the start of 2025. That level of attention gives her a kind of leverage that a parent fighting alone in family court 20 years ago they wouldn't have had it.
And critically, she's moved beyond just sharing her story. Through her Learn with Meg workshop, she's actively teaching other parents how to navigate the system.
Things like legal literacy, how to file pro se motions, how to use tools like Court Listener to find the legal precedent you need.
It transforms her fight from a personal quest for damages into a collective movement seeking structural reform and transparency.
So Meg's pursuit of justice is defined by this immediate, aggressive challenge to the systemic function of the court and DCS structure in 2024. And she's leveraging technology and public attention to bypass or overwhelm that traditional slow process.
Which sets a very clear picture of the modern fight. Now, to fully appreciate her strategy, we really need to contrast it with a legal battle that was fought in an analog world. A battle where digital visibility wasn't an option, and the only path forward was painstakingly fighting through the courts for 2 decades.
The saga of Presley Hardwick.
Exactly.
The Hardwick case is a deep dive into the legal and emotional trenches of Orange County, California family law, and it starts all the way back in the mid-1990s.
This was a decades-long pursuit of accountability, led first by the mother, Deanna Fogerty, and then carried on by her daughter, Presley.
And the divorce that started it all? It was explosive.
It was. The source material details an extremely high conflict environment, and it was driven by Mr. Hardwick's significant substance abuse history, including alcoholism, crystal meth use, and sex addiction.
And that volatile backdrop led directly into this severe custody battle, which centered on allegations of molestation.
Yes, involving their eldest daughter, Kendall. And Kendall had been diagnosed with mild autism and pervasive developmental disorder, which made her particularly vulnerable.
So given the severity of those allegations and the complexity of the child's needs, you'd expect the court to be extremely cautious.
And they were. This is evidenced by the fact that the custody court retained 3 separate, well-qualified psychological experts over 2 years.
3 independent experts. That shows the court was serious about getting the facts right.
Dr. Howell, Dr. Johnson, and Dr. Rogers. And this consensus of experts, what did they conclude about those core molestation claims?
All 3 independently ruled out sexual abuse. Dr. Rogers, whose 70-page report was particularly influential, she explicitly concluded that the sexual abuse allegations were false.
And not just false, but that they had been shaped by the mother, Mrs. Fogerty.
Right. She noted that Kendall's condition made her very vulnerable to manipulation.
So this established a baseline of skepticism among the court professionals about the mother's motivations and the truthfulness of these allegations.
That context is just. It's vital. And yet, just as the father was pressing the court for a final custody review in late 1999, the whole situation completely inverted.
It did. In November 1999, Kendall suddenly disclosed a lifelong pattern of abuse to her therapist, Dr. Mitchell.
And Dr. Mitchell, as a mandated reporter, she had to report it.
She had to report it, which triggered the juvenile dependency proceedings and put the divorce case on hold. But Dr. Mitchell also documented the highly suspicious timing of this disclosure.
What does she know?
She noted that Mrs. Fogerty seemed very excited when she was told the mandated report had to be made.
The alleged excitement. When you put that next to 3 previous expert findings that the child was being shaped, that must have raised some serious red flags for the court.
Absolutely. The juvenile court proceedings began in November 1999, and the court immediately established very strict boundaries. The judge specifically warned Mrs. Fogerty against discussing the case with the children.
And explicitly threatened removal to Orangewood Children's Home if she ignored visitation orders or used the children as leverage.
The record shows the judge was remarkably precise in these warnings.
So what was the tipping point? What led to the execution of that threat?
The warnings were continuous, and they were escalating through early 2000. On February 8, 2000, the judge stated very clearly, "If I get word that we are missing visits, I am likely to pull the children from you and have them at Orangewood."
And the evidence that came out in the following days suggested Mrs. Fogerty just ignored that.
Right. So just 9 days later, on February 17th, the court learned that a scheduled visit had been missed.
And there were other reports too, right?
Yes, confirmed reports that Kendall had inappropriately discussed the court monitor, and Mrs. Fogerty was reportedly heard telling one of her daughters that their father was trying to take them away.
Which would be seen as a direct, willful violation of the judge's order not to poison the children's minds or discuss the litigation.
The judge's response was decisive and blunt.
And it confirms the court's core concern about parental alienation.
The judge stated, quote, "You are using these children, ma'am. There is no question in my mind." And on that basis, the court ordered the social workers, Marcy Vrieken and Elaine Wilkins, to remove the children forthwith.
And the official basis for that removal was parental alienation and violation of court orders, and that's why they were placed in Orangewood.
Correct.
Okay, so now we transition from the family court proceedings to the constitutional challenge. Because Presley Hardwick's subsequent federal lawsuit against those 2 social workers alleges something far more damaging than just poor judgment.
That's right. Presley's lawsuit, which was filed under 42 U.S.C. Section 1983, claimed the removal itself was unconstitutional. Because Vrieken and Wilkins allegedly engaged in judicial deception, the claim had 2 parts. First, that they deliberately lied to the court on February 17th to get that immediate removal order.
And second.
And second, that they lied again on March 31st by concealing critical reports from Dr. Mitchell, the therapist, showing the girls were decompensating and acting out angrily while they were in foster care at Orangewood.
This distinction is so crucial for understanding the fight for justice in the Hardwick case. The claim isn't about whether the judge made the right call. It's about the integrity of the evidence the social workers presented to the judge.
Precisely. And the district court in Presley's federal civil suit was very clear about this. The trial was narrow. The long, complex history of drug abuse, sex addiction, even the earlier expert evaluations ruling out abuse, all of that was deemed not relevant to the specific claims against the social workers.
The only thing that mattered was whether those specific alleged deliberate misrepresentations by Vrieken and Wilkins caused the removal order.
That was the entire case.
So after the removal, what was the final outcome back in the family court?
The family court case actually resolved pretty quickly after that. It followed Dr. Rogers' detailed recommendation. Miss Fogerty ultimately stipulated to a final plan.
What was in the plan?
It granted sole custody to Mr. Hardwick with supervised visits for herself. And this outcome was explicitly based on the court's determination that her inappropriate statements had constituted poisoning the children.
This brings us to what is maybe the most painful twist in this entire saga. The testimony of the daughter who first made the molestation allegations.
Yeah. Years later, Kendall, the elder daughter, she filed her own civil lawsuit that mirrored her sister's, but then she dismissed it.
And
then she provided what was described as highly emotional and explosive testimony under oath in Presley's lawsuit. After waiving her Fifth Amendment rights, Kendall testified that her father never abused her, that her mother coached her to lie.
She said her mother coached her.
Coached her to lie. And that the mother and her former attorney had coerced her to continue those lies in the subsequent litigation.
Wait, so she went on record, under oath, to confirm that the abuse allegations that started this whole dependency process were false, that her own mother coached her to lie, and that the social workers, the very people her sister was suing, had done nothing wrong.
Yes. She explicitly testified that removing her and Presley was the absolute right thing for their welfare.
That testimony, it must have fundamentally complicated Presley's federal civil rights claim. Even if the social workers did commit judicial deception, this affirms that the court's ultimate decision to remove them was justified on a separate basis.
On the separate basis of parental alienation and emotional abuse. It's an incredibly complex situation.
This just highlights the immense difficulty of using a specific, narrow, legal claim judicial deception on two specific dates to counter a lifetime of complex family dynamics, especially when your key witness recants.
But the real reason this case became a landmark legal battle wasn't really about the facts. It was about the legal shield protecting the defendants.
It was all about immunity.
It was entirely about immunity. Presley's lawsuit sought damages against the social workers and the county, and the defendants argued they were protected by both absolute immunity and qualified immunity.
The ultimate hurdles in these Section 1983 cases.
The ultimate hurdles.
Okay, so let's break down that immunity defense, because this is essential to understanding the difference between these two deep dives. First, absolute immunity. What is that?
Absolute immunity is basically a blanket protection for officials. It protects the job. It shields state officials, including social workers, when they're performing what are called quasi-judicial functions.
Which would include things like filing petitions, presenting evidence.
Or, critically in the Hardwick case, executing a specific court order. The defense argued that even if they lied or concealed evidence, they were performing duties integral to the court's decision-making process and executing the judge's clear order to remove the children forthwith.
So that shield is incredibly difficult to pierce.
Almost impossible.
But then there's qualified immunity, or QI, which is more complex, and it depends on the legal context at the exact time the misconduct happened. This is the one that has really sunk so many of these older cases.
Right. Qualified immunity protects the individual official. It protects the person. It shields government officials from liability for constitutional violations unless the right they violated was clearly established at the time of the misconduct.
And in the Hardwick case, the alleged lies and concealment happened in February and March of 2000.
So the critical legal question wasn't whether Vreeken and Wilkins committed judicial deception. The question was whether the specific constitutional right not to be removed based on deliberately falsified evidence in a civil child abuse proceeding was clearly established by case precedent in the Ninth Circuit in the year 2000.
And what was the answer?
Well, the social workers cited the Ninth Circuit's own 2010 ruling in a case called Kostanich, and this ruling is the linchpin of their entire immunity defense.
What did the Kostanich court say?
The Kostanich court held that while the constitutional right not to be accused based on deliberately falsified evidence was clearly established in the criminal context, I think of a police officer lying on an affidavit.
Right.
It was not clearly established in the context of civil child abuse proceedings back in 2001.
Wait, if it wasn't clearly established in 2001, then legally, there is virtually no way it could have been clearly established in 2000 when Presley was removed.
That is the cruel legal technicality of qualified immunity. Because the law wasn't clearly established according to the Ninth Circuit's own interpretation until after the events of 2000, a reasonable officer in their position could not have known they were violating a constitutional right that was sufficiently defined by precedent.
So even if a jury later found the social workers fabricated evidence, the appellate court could still hold them immune from being personally liable for damages.
That's right, and that's the lesson here. Using the courts to get justice for a constitutional harm that you suffered decades ago when you're targeting individual state actors for damages relies almost entirely on the legal precedent that existed at the exact moment the harm occurred.
It demonstrates the fundamental purpose of the Hardwick path. A decades-long struggle focused solely on financial compensation and trying to pierce that immunity shield.
And now we can really move to the comparison and see how Meg's approach 2 decades later fundamentally changes that entire pursuit of justice.
Okay, so if we connect these two complex cases, what we're really seeing are two different generations trying to hold the state accountable when familial rights collide with state authority.
Right. Meg fighting in the digital age, and the Hardwicks who are fighting in the legal trenches of the analog era.
Let's look at the legal outcomes first, focusing on what the mother and daughter actually achieved in the Hardwick saga. What did they win?
Well, Miss Fogerty Hardwick, the mother, had an early limited jury win in her own civil suit. The jury found her constitutional rights were violated.
But the sources note a key limitation there.
A huge one. In that specific trial, the jury wasn't allowed to hear the critical evidence about the false molestation claims, the earlier expert evaluations, or the final custody findings against her.
So her win established a violation, but it didn't necessarily establish liability against the specific social workers in her daughter's later case.
Exactly. When Presley pursued the civil case for constitutional damages against those individual social workers, she ran straight into that wall of qualified immunity.
Her goal financial compensation for the constitutional violation was undermined by the legal timing of the precedent, the fact that this all happened in the year 2000.
So Presley's path was all about trying to win damages against individuals, and it was an uphill battle from the start.
Now you look at Meg, fighting in 2024. She has a very different profile. She initially won her divorce, but then she suffered that sudden loss of custody ex parte. Her success so far is defined by this massive national visibility.
And her tenacity. The ability to sustain multiple, complex pro-se actions, and using that pivotal recorded evidence of the DCF clearing her.
So her focus is still on damages through federal court. But she has this secondary, and you could argue more successful, path of systemic reform and advocacy.
And that means the two mothers define accountability in fundamentally different ways based on the tools that were available to them.
So we're talking about two different definitions of justice here?
I think so. Meg's model is focused on future prevention, on legal literacy, on legislative pressure. She defines justice as forcing structural change and empowering other parents through resources like Learn with Meg.
Her legal strategy is to use the swift, blunt force of federal civil rights law section 1983, 1985, and 1986 to challenge the systemic functioning of the court structure today.
Whereas the Hardwick model, especially Presley's federal suit, was this prolonged, intense effort to prove specific malfeasance, that judicial deception, in order to set a precedent and achieve financial justice for a specific harm that happened in the past.
It was less about policy reform and entirely about proving individual liability for a single, discrete act.
The trade-offs are significant. Meg is leveraging public visibility, which brings immense pressure, but that could also, potentially compromise the judicial fairness of her civil suit in the eyes of the court actors.
Right. And the Hardwicks, they stayed in the judicial trenches for decades, seeking a quiet, definitive legal victory. But that path proved incredibly taxing emotionally and ultimately failed on the specific question of damages because of immunity.
Which brings us back to what I think is the most fascinating legal nugget of this entire deep dive: the immunity time warp. This is what makes Meg's legal path structurally different than Presley's.
Okay, let's spend some time on this. Explain one more time how that Kostanich case created a legal trap for the Hardwicks that might not exist for Meg today.
Sure. So qualified immunity requires the law to be clearly established. In the Ninth Circuit, the Kostanich ruling in 2010 essentially drew a line in the sand. It said that the right not to have your child removed based on a social worker's deliberately falsified evidence was only clearly established going forward from around the year 2001.
Meaning, if a social worker fabricated evidence to remove your child in 1999 or 2000, they could be held immune from damages because the case law hadn't clearly defined that specific constitutional violation in that specific civil context yet.
Exactly. Even if their conduct was later deemed wrongful, they get a pass on personal liability for damages. Now, you fast forward to 2024.
Right.
Meg's lawsuits benefit from all the subsequent rulings that have potentially clearly established many of the rights that were violated. This gives her a far better legal footing, theoretically, to overcome the qualified immunity defense than the Hardwicks had 2 decades ago.
So the bottom line is Meg might win where Presley couldn't, simply because of when she's fighting this battle.
No. In large part, yes. The law has evolved to offer more protection to familial rights in this context.
But the fact that Presley Hardwick had to endure a decades-long fight to secure a monetary remedy, only to be blocked by the timing of a legal precedent, it raises a really profound philosophical question about what justice even is.
It does. It requires immense financial and emotional capital to fight these systems. Meg, an ordinary mother, she had to become a pro-se federal litigant, mastering the intricacies of Section 1983, and a national media expert just to keep her case alive and visible.
And the Hardwicks had to endure years of litigation, appeals, and this painfully complex testimony, including Kendall's emotional recantation that actually affirmed the social worker's basis for removal, even while Presley's suit was alleging deception. The sheer cost to these families is just staggering.
These cases fundamentally challenge the necessity and the scope of the immunity doctrine. If qualified immunity is designed to protect officers making split-second decisions, does that protection legitimately extend to court-appointed experts and social workers who allegedly deliberately fabricate evidence or conceal exculpatory findings over weeks or months?
The systems are designed to protect the integrity and function of the courts, right? To ensure that government employees can do their job without fear of constant litigation.
But these stories reveal that when those protections are absolute, or when they're retroactively applied, they can leave families feeling utterly violated and without any real recourse. They can create a barrier to justice.
So we've seen two distinct approaches to achieving accountability. Meg's story shows the enormous power of public truth and digital organization when traditional institutions fail to provide due process.
And the Hardwick saga shows that even when facts suggesting deception emerge, the legal protection afforded to court actors through doctrines like qualified immunity may mean the path to receiving financial justice for those harmed remains profoundly difficult, sometimes impossible.
Even if the eventual outcome, the child's safety, was deemed appropriate by the child herself, it seems like the protection of judicial immunity can sometimes dramatically eclipse the protection of fundamental familial rights. That's the critical tension that remains unanswered.
Which raises an important question for you, the listener, to mull over. If the viability of a lawsuit depends entirely on whether a constitutional right was clearly established decades ago, even when the underlying facts of misconduct are later proven, does the concept of justice become purely a matter of legal timing rather than moral fact?
A heavy thought to leave you with after this deep dive into two incredibly challenging legal terrains. Thank you for joining us for this extensive exploration of family court, constitutional rights, and the very different paths taken to seek accountability.
We encourage you to continue exploring the evolution of the qualified immunity doctrine and the complex interplay between systemic protection and individual rights.
Until the next deep dive, stay curious.